Earlier this morning, we had the chance to speak to one of Mr. Trump's defense attorneys, John Lauro. We started with the timing of a trial. The special counsel said yesterday he would like to see a speedy trial. That is 70 days from now. Are you ready to go? Would you like to see a speedy trial?
Well, the speedy trial right is the defendant's right, not the government's right. So we're entitled to understand what the charges are. We're entitled to do our own investigation. The special counsel or the Justice Department, the Biden Justice Department, has had 3 years to investigate this. To take President Trump to trial in 90 days, of course, is absurd. The question is, why do they want to do that? If you want to seek justice, then you need to offer President Trump an opportunity to get a hold of all the evidence and understand what the facts are.
Well, I assume you're confident you can win this case.
Absolutely. We're going to win.
Yeah. Would you, at a minimum, say you'd like to see this resolved before the election?
I want to get to all the evidence. I want to have a chance to present our case to a jury. This is the first time that the First Amendment has been criminalized. It's the first time that a sitting president is attacking a political opponent on First Amendment grounds and basically making a criminal to state your position and to engage in political advocacy.
I've got to give you a little time out on that one because, of
we've
course,
never seen that before.
Well, the indictment specifically says that the president has a First Amendment right to speech.
Yes.
He even has a First Amendment right to lie. It says it right here.
Absolutely.
This indictment is criminalizing conduct, not speech.
No, it's criminalizing speech for this reason. What the president saw in the 2020 election was all these irregularities going on. Okay, affidavits, sworn testimony, examples of instances where the rules were changed in the middle of the game. He had every right to comment on that and act politically. In a criminal case, what they would have to show is all of that speech was not entitled to First Amendment protection.
But we're not talking about
They'll
speech.
never be able to do it.
It's very explicit. It says, though Jack Smith saw this very argument coming, it says he is being indicted for conduct using unlawful means of discounting legitimate votes and subverting the election results. He says he can speak all day. He can't engage in conduct.
Of course, you can take action in the political sphere. For example, let's say somebody opposes a law in Congress. Do a filibuster, right? That's political speech. That's political action. There's nothing wrong with that. But what we have something that no one else realizes.
There is something wrong with sending fake electors, trying to go beyond and around the law.
These weren't fake electors. These were alternate electors, which John Kennedy did in 1960. It was an exact protocol that was followed previously.
Different situation, and the indictment alleges that some of these alternative electors, I'll use your words, weren't even aware. They thought this would only come up if there were a legitimate dispute in court.
Absolutely, and what President Trump had was an actual opinion of counsel that his request to Vice President Pence was completely lawful and completely constitutional.
He also had many opinions of his own White House counsel that was not legal.
No, you're entitled to believe and trust advice of counsel. You had one of the leading constitutional scholars in the United States, John Eastman, say to President Trump, this is a protocol that you can follow. It's legal. That eliminates criminal intent.
That is one lawyer. He had his White House counsel saying that was not true. This is a fringe legal theory.
Here's the thing, though. The government in a criminal case has to prove beyond a reasonable doubt criminal intent and corrupt intent. They have to demonstrate beyond a reasonable doubt that, number one, President Trump did not believe that all these irregularities were true, and number two, that he did something to corruptly obstruct justice. And they can't prove that because everything he did was to get at the truth, filing lawsuits, asking for recounts, asking Vice President Pence, pause the counting so you can go back to the states and re-audit.
The prosecutor says, let's go to trial. I'm ready in 70 days. Fair enough. You're not ready in 70 days. How about 90? How about 6 months? How about before the election?
How about he had 3.5 years? Why don't we make it equal? Okay. The bottom line is that they have 60 federal agents working on this, 60 lawyers, all kinds of government personnel, and we get this indictment and they want to go to trial in 90 days. Does that sound like justice to you?
Well, maybe.
Is that justice?
The prosecutor's not here to say. Maybe he's investigating so that he's ready to go to trial in 70 days.
Is it justice to force a former president of the United States to trial in 90 days when you've had 3 years to investigate?
Well, as you well know, no one can force that. As you pointed out, it is the defendant's right to a speedy trial.
Why would a prosecutor ask for that? Why would a prosecutor seeking justice, seeking truth, try to force a trial?
Well, I don't know, but you just told me 10 seconds ago that they wanted to tie him up in court so he can't run for election, and now you're telling me they're trying to force the speedy trial.
Right now.
So which one?
The election's going on right now. They want to go to trial so that instead of debating the issues, news against Joe Biden that President Trump is sitting in a courtroom. How is that justice? The American people want to talk about the issues. What they don't want to do is relitigate the 2020 election.
Hey, thanks for watching. Don't miss the Today Show every weekday at 11 a.m. Eastern, 8 Pacific on our streaming channel, Today All Day. To watch, head to today.com/allday or click the link right here.